I am a lawyer, but I'm going to try to avoid as much as I can talking about the law. The subtitle of my talk is Know Before You Go. And so my point is to try to give you some tips about how to do business in the United States, things to avoid, maybe things to do to protect the profitability you hope to achieve by entering the U.S. market. I'm going to talk about 4 principal topics, which are intellectual property rights, establishing a U.S. presence, talking about some issues for entering into contracts with parties in the United States, and then lastly, U.S. product liability. I leave that last because if I said it first, most people will be out the door before I finish my talk. And I'm also going to be talking generally. If I do happen to wander into the area of law, I'm going to be talking very broadly. As Lord Green mentioned, of course, there are 50 states in the United States. There is the federal government, and in each of those jurisdictions, there is a legislative body that creates the law. There's an executive body that administers and interprets rules and implements that law. And of course, there is a judiciary that interprets those laws when there are disputes. And in the United States, the courts are very proactive. And so in effect, their decisions make law. All very, very confusing. And it reminds me of the story about the surgeon and the engineer and the lawyer who were arguing about whose was the oldest profession. The surgeon says, well, it's easy, and actually it's documented. In the first book of the Bible, it says that God created Eve out of Adam's rib. Surgical procedure, there you go. The engineer said, yes, you're right, it is the book of Genesis, but it's actually the beginning of the book of Genesis where it said God created heaven and earth out of chaos in 6 days. Engineering. It's got to be. And the lawyer said, who do you think created the chaos? That is not my goal, or at least not today. So what I'd like to do is start with intellectual property rights, and to do that, I'll get onto a slide that should say that. Oh, next. Let's see that one. There it is. Okay, good. Thank you, Nick. There are just a few points here. First of all, intellectual property rights are territorial. So generally what you have here isn't going to protect you in the United States. That's certainly absolutely true in patents, patents. And if copyright and trademarks, there is some protection. Copyrights by reason of a treaty, trademarks by reason of common law. But the bottom line is you can improve your protection for your intellectual property by doing something in the United States. And your intellectual property is a terrific asset of your business. You know, whatever you're selling, whether it's a good or a service, that intellectual property is a foundation building block of your business, and it requires protection. It's not that hard to get trademark and copyright protection. It's very simple, relatively cheap to make a filing, and there are advantages to improving your rights in the United States by registering. First of all, if you're registered, if your application is accepted for registration and you're registered, then you're deemed, at law, to have priority to that bit of intellectual property. So if anybody wants to challenge you, or if you want to enforce it, you have the uphill position in the battle. They have to attack your registration because at law, you're deemed to have the right to use that particular bit of intellectual property, and they are not. That's a good starting point. Another point is, in the course of proving things, you have an easier job if you've registered. You can get what are known as statutory damages without having to prove your actual loss. And it's hard to prove loss if you haven't been in the market long enough to say what sales you might or might not have had if this no good hadn't been using your intellectual property. Another advantage, of course, is you get attorneys. You can get the court to award you attorney's fees. And there's a distinction you should be aware of if you aren't already, that unlike in this country where the loser generally is required to pay at least some of the winning party's legal fees, in the United States that does not apply at all except in 2 situations. One where the parties have already agreed by contract that will be how they will resolve their dispute, or the end result of resolving their dispute is that the loser pays. The other is if the particular law associated with your lawsuit, federal trademark law, the federal copyright law, for example, permits the court to award fees if you win your case. It's very helpful, unusual in the U.S. system, but it's another incentive for registering your intellectual property rights in the United States. The last point is protecting trade secrets. Trade secrets are really amorphous. You don't register them anywhere. You are in absolute control over what you do and what you tell people and how you tell them and how you protect them from using that information in a way that you don't want them to. You want them to do that. You do that, you protect it by contract. You can have an oral contract, not so good because you don't know. There's likely to be a dispute as to what people said and what they agreed to. So you have a written contract, and that's a highly recommended if you want to take a first step anyway to protecting your trade secrets. You have to be sure that you're protecting them as you want somebody else to protect them, because if you're not protecting them yourself, the courts may be loath to let you protect them in the United States. So then I go on to the next point, which is establishing a U.S. presence. The normal process is that people start putting their foot in the water, going on a trade mission, sending salespeople over. There may be issues about getting U.S. visas, and I'll talk about that in a minute. And then they decide they want to enter the market more physically. So they might enter into a contract with an agent or a distributor. And there are a couple of points I want to make about those relationships. First of all, about half of the states in the United States have variations of distributor protective laws, and to some extent, or lesser extent, agent protective laws. So there are things you may be able to contract or get your U.S. party, the distributor agent, to contract out of those, or some of them you can't override by contract because they're designed to protect the local distributor or agent for historically valid reasons. It isn't just xenophobic. But anyway, it's important to know the whole point of contracting, the whole point of entering into a relationship is to anticipate how things are going to go, how they're going to start, how they're going to continue, and how they're going to end. And you don't want to be blindsided because a law that you didn't know about disrupts your expectation of how this relationship was going to go or what you would have to do during the course of the relationship at the end of it. So it's important to keep that in mind. On the agent side also, I'll skip ahead a little bit. You don't want to have the U.S. government or the state governments take more tax. This is a very sensitive topic these days. Take more tax than they should from your economic activities in a particular state or in the United States. So it's important to understand the rules of the road. And one of the ways people sometimes trip up is they hire an agent to do business for them, and they allow the agent to close the contracts in the United States. That's a no-no because that's a no-no because that will mean that the agent is your permanent establishment and you're then subject to tax in the United States. It's a whole subject I don't want to get into, but it's something to be wary of in terms of contracting with an agent, in terms of who has the power to close the contract. Generally, you don't want to give your agent that power. You want the contracts to all be closed in the UK and not in the US. The next point is corporate issues. If you decide then you do like the market, you're happy with the distributor or agent, but you want to have your own people over there, you want to set up a business, the corporate issues, I don't want to get boring, but it's branch or subsidiary. My one point here I want to talk about, and again it's a tax issue, is a limited liability company. Many companies, particularly smaller companies in the United States, operate in this relatively new form. It's terrific. Basically, it's terrific because it's a tax device. It saves one layer of U.S. taxation. And people, it's very, very attractive. It's a terrific device. Unfortunately, it's not a good device for British investors, or British companies, British owners setting up in the United States. And the reason for that isn't because it isn't a good U.S. tax device, but it's because it's not a good British tax device. For years and years and years, HMRC has taken the position that they're going to tax an American LLC differently than it's taxed in the US. And this creates dislocations of tax credits, when something is taxable, when it isn't. And the bottom line is there's a significant risk of double taxation on the profits your business makes if they make them through an LLC. So if you are talking to somebody who's helping you set up a business in the United States and they mention an LLC, just ask them this question. Do you know anything about the UK taxation of an LLC? If they don't, back up and start again. You want to set up an ordinary, what they call a C Corp, to avoid the British tax consequences. Staffing issues are relatively simple. Employment issues in the United States, it's hire and fire. It's the old common law system. You just clear your desk, Charlie, you're gone. That's it. No, unless there's discrimination, age, sex, race, gender, whatever else, which are generally federal laws, you can hire and you can fire anybody anytime. And so there are no employment contracts, or generally there are very few contracts unless somebody wants to. It's a very highfalutin person who has stock options, and you have to explain how those work, or if the person has access to confidential information that you want to restrict after the person leaves your employment. You need something in writing to protect yourself in that regard. So there would be you'd want an employment contract in that situation. I mentioned work visas. Let's see. What you can do, the first thing I just want to, well, first of all, there's something in the handouts about the A to Z alphabet soup of visas. And so there's a lot of description in there that I won't get into. The one question I do want to talk about is what you can do on the visa waiver program or going on a B visa, business visitor program. First of all, I want to dispel something. A common myth that the visa waiver program means you don't, because you're British, you can go to the United States and work without a visa. No, not true. You can only go to engage in business conduct where you are not affecting a profit for a U.S. entity there. So where you're engaged, you can't be engaged in productive activity in the United States. So what does that mean? There's a huge gray area in there, and the simplest way to explain this is by way of the Hong Kong tailor who places an ad in a New York paper and says, I'm going to be at the XYZ hotel for this weekend. If you want to buy a suit from my company, come there, I'll measure you up, I'll go away, my folk will run it up, and then I'll bring it back, you'll pay the rest of the fee, and we'll do the final fitting. And that person is not working in the United States. And most people wouldn't understand that as a concept, but that's what the U.S. immigration law says, because the principal purpose of that person, of the tailor coming to the United States, is to sell something from abroad. The purpose is international trade. The tailor, of course, the tailor is taking measurements, doing the fittings, but the principal purpose of that is to sell a suit from Hong Kong. So that person doesn't need a work visa. They can go on the business visitor visa. I'm going to have one-to-one sessions. If anybody wants to talk about this later, I'd be delighted to do that. Now, skipping right on to the next section, governing law. This is an interesting concept, not easily resolved, but people say, well, I want English law to govern this contract because I'm comfortable with it. And people in the United States, not unnaturally, say, well, I want the law of Massachusetts, my home state, to govern this because my lawyers have advised on this contract. This is my form contract, and I'm comfortable with this. And besides, I don't know anything about England, Schmengland. I don't know. I want to buy your product. That's all. I don't want to learn your laws. And it is a difficult issue to broach, and you have to think about what's the effect of this, though. For example, getting back to intellectual property, if you have a restrictive agreement with somebody, and you say, all right, let's have this governed by English law, but the person is in Nevada. An English court can't issue an injunction to stop somebody in Nevada doing something in contravention of their agreement. They don't have the power. Injunctive powers are territorial. So you're going to have to go to a court in Nevada. And in Nevada, you're going to have to prove to the Nevada judge what English law is on this particular issue. So there are reasons for thinking carefully about what the governing law is, or exceptions when you will provide the governing law of the local territory. And my only point is, my practice position has always been write your English contract if you want to, with the view to an American court looking at it. And the reason I say that is because things are done differently in America. And I'll talk about disclaimers and limitations of liability. And that is difficult because they do things differently in the United States. The law's been similar since the turn of the 20th century. And the point is that they have a concept of unconscionability. If you've ever looked at an American contract, the fine print, there's a word that you'll never see anywhere else. It's called merchantability. And the reason is, both in the UK and the US, a seller gives an implied warranty of merchantability. Now it's called satisfactory condition here. And to disclaim it, you have to put that in writing. In the United States, you have to put it in writing and make it conspicuous. So if you ever see a form contract in the United States and you look through it carefully, you'll see some point at which the language is blown up. It's highlighted, it's different color, it's whatever. It's to make it conspicuous, to make that particular term enforceable. So there's a little trick for you if you have a form contract you want to use in the United States and you have a disclaimer, make it conspicuous. Otherwise, it won't be enforceable should it work its way into a US court. I'll skip over my favorite topic of attorney's fees because I think I've already covered that. Well, occupational hazard.
And expensive.
Could be. It depends if you've gotten the other side to agree to pay your fees. I just want to make one or 2 points on product liability. First of all, it's a question of if you make a product that's safe, you have to look out for American standards instead of British standards. They're different sometimes, but you have to anticipate how your product's being made in the market. I gave one of these talks a number of years ago, and in a one-to-one session, someone said, well, I make some kind of big cardboard hacking and bending machines. And so you get these heavy sheets of cardboard. You've seen them around washing machines, refrigerators, and then our machines sort of crimp and cramp, and then they bend them and everything's wonderful, but these things are dangerous. So we put guards on, they have dead man switches, you take the guards out, the machine stops. And I was visiting one of my customers in the United States, and they proudly took me to see how my machine was working. And when I got there, I was horrified. The guards were off and the machine was running. I said, what's happened? What's happened here? And he said, yeah, we noticed the problem with your machine. Every time we took the guards off, the machine stopped. It cut our efficiency. And she said, is there anything I should do about this? I said, yes, because she knows now that that dead man switch has been circumvented. Somehow someone's been able to re-engineer her machine. Is she liable? I don't know, but she knows about it now. The thing is, she knows about it. She knows. So one of the things about the feedback loop is it's a constant process. Once you make your product as safely as you can, get into the market with the adequate instructions, adequate efficient warnings, then that's not the end of it, because it's a feedback loop. If you learn things from the market, you're going to be held to account for taking those into your thought process when you continue making that product, continue selling it, whether it's re-engineering it, whether remanufacture or re-engineering the manufacturing process. It's how you explain the product, and that leads me neatly to the next point. I'm getting close to the end. When you start to write your product literature, it looks like this. Yes, that's the right side. It's a blank piece of paper, and you're in total control over what you say about your product. And in the United States, and to some extent here now, but still much more in the United States, it's a manufacturer's or seller's duty to effectively warn of the hazards and to adequately instruct about how to use the product safely. And if you don't believe me, go to Costco in the United States, go to Walmart in the United States, and start looking at the products. Buy a product and look at the instruction manual. And it's not hard, but it's there. And you see the first 10 pages. I just bought a TV here. And I had to go through 20 pages of these warnings and stuff before I could figure out how to plug it in. It's crazy, but there it is. It's part of the law. It's required, and you need to give a lot of thought in terms of how you're selling, not into this market, but you're selling into the American market, where the language is as likely as not to be English, or where the reading capacity is a lot less than it is here. So don't let sorry, I don't know if I'm offending anybody, don't let your engineers be the only people who write your product literature. It's got to be written so that it is understandable by the common person. And that's not really a US-centric bit of law, but it is important. And finally, we did talk about, well, I did talk a little bit about litigation. In product liability litigation, the key to winning those cases is often your company records, because in the United States, the plaintiffs can ask you to divulge your product, your records and your discussions, and go back and see what your people were actually talking about and what they did. So the 4 questions to ask yourself to reduce your product liability risks on that side is, what did you know? I'll get this right. What did you know about the problem or safety issue? When did you know it? What did you do about it? That's a key question. What did you do about it once you knew it? And then what could you have done? And those are important questions to ask yourself as you think about reducing your product liability risk. It's possible, it is doable, and the risk is reducible. It's not you can't absolutely avoid it, but you can reduce it and be sensible about protecting your profitability by taking those types of steps. I've rattled through this. David has given me a signal quite some minutes ago. So I'll finish. Thank you very much for your attention, and I'll be around for one-on-one later on.